So, welcome everyone to a discussion about the new listing contract form that Michigan Realtors has provided to us. We are going to go over it as a group. I know we have about 10 people on the Zoom, a couple people here in the class. I am going to be putting it up on the screen so that way then, yeah, we can all go through it, and that way then, at least with the recording, everything is not just the camera of this room, because does not make for very entertaining video. So let me go ahead and share the screen. And what I wanted to start out with in sharing the screen is showing how to get to, again, I thought this computer was updated and still the Zoom share is slow. All right. So starting out now, for those who are not Real Comp members, if you're Paragon or Flex, it's going to be obviously different. But for those that are Real Comp and then use Remine, blocking my path. So in our Docs Plus in Remine, this is how we're going to access the form so we can review it on screen together. I do have the printout in front of me. And I did attach it as a PDF with the Zoom link. So if you want it on your own computer, it is there. Although I realized that what I attached did not brand automatically. So that's where when you use the forms in Remine, it should add our branding to it by default when you sign it to a transaction, but playing around with just a blank form does not automatically add the branding. But yeah, so when you're in Remine, over here you have the forms, little tab on the left, and then it's going to be in the Real Comp filing cabinet. It's not a Remax Platinum form. So in the Real Comp filing cabinet, and then in the Michigan Association of Realtors folder, that's where all of the new forms are. I believe they're all currently updated. And that includes both Form BB, which is what we're going over today, and JJ, which is what will be next week's class when we go over the buyer contract. So to pull up the listing contract, BB, and we want BB-1 rather than B-1, since we are a designated agency office. The traditional agency offices where two agents from the same brokerage, if they collaborate on a deal, they automatically become dual agents. We don't do it that way. We like to remain seller's agent and buyer's agent while the brokerage becomes a dual agency brokerage. We as agents remain our selling or listing agent. So here's the form. I'm gonna download the PDF and then open it up on the screen. Actually, you know what? No, I'm going to instead use now and create a new transaction, because this way we can play around with the smart boxes. So I'm going to be on the listing side, address. Somebody give me an address.
2705 Aurelia.
What is it?
2705 Aurelia, Aralia.
All right. I don't need anything else. I just wanted this one form. All right, so we have here listing form. So what I do want to go over, and you see here now it did add the branding automatically because we've added it to a transaction in Remine. So that makes it very nice for us. And now if you show up or watch the video for next Tuesday's sales meeting, I am going to do a quick refresher on your packages and updating your packages or creating brand new packages. So that way then when you go to use a document like this, more of these things can already have been filled out. So that way then you don't have to each time type in Joseph DeCrube and, certain things like that. But yeah, so let's begin in going over the content found within. Now, the goal of it is to be able to do the 30-second pitch, the 3-minute pitch, and the 10-minute pitch. The 30-second pitch, the point of that is if you're listing your mother's house, she's going to sign the document. You don't have to really worry too much about explaining, that trust is already 100%, or should be, hopefully. Depending on your relationship. But yes, if you've got that relationship where they're just waiting to get to the signature line, you want to be able to quickly go through and say, okay, so yeah, this just lays out the people involved, this is the property, all of the stuff affixed to the property, you're including in the sale. Here we're going to check the box based on when it was built. This is the price that we're going to list at. Compensation, we're going to do 6%, and then we're going to share it, with 3% down here to any buyer's agents. The seller concessions, we don't need to have any of those right now. If somebody writes an offer and they sacrifice their EMD because they, walk away from the deal 2 days before closing, you're going to get 100% of that EMD. I'm going to take 0%. I'm going to put a lockbox on. We're not going to be able to accept any other offers once we get one that's binding. We'll give them possession at closing. You're not allowed to discriminate. If somebody writes a love letter, I'm not going to forward that on to you. Just because I think that that's risky in terms of fair housing. We're going to allow showings to occur, and if we get into a possible situation where I'm representing the buyer as well, I'm going to act as a dual agent. Aside from that, the boilerplate, nothing too serious. You can go ahead and sign down here. That's the 30-second pitch. That should really only be, if they were ignoring you, from the get-go. If you could tell they didn't care what you were saying, they were just waiting to sign. Now, the 3-minute pitch is the most common, which is you're going to have to, but in order to do the 3-minute, let's do the 10-minute. Let's say you get that client who wants to know every single component in this document, explain it to them in layman's terms. We got to be able to have that in our arsenal because we never know when we're going to come across that client. And if you can do that, then the 3-minute pitch and the 30-second pitch are easy. So the 10-minute understanding of it all, that's what really matters. So starting up at the top, our contract date is when it begins, through an expiration. So let's actually do it. So we're going to do, yes, it is August. All the way, let's say through March 31st, although that's actually more than normal. So, this is the brokerage involved. This is our address. I am the designated agent. Now, the broker is Joe DeCrube. He's my broker. I am one of his agents. You as the seller, John Doe, and your address is 123. Well, I am way off on the keyboard. Main Street. Right. Let me get your email address, johndoe@gmail.com. Oh, and janedoe@gmail.com.
Oh, there's two.
Yes.
That's new.
Yeah. Jane Doe. And that's where also when you add them, you can edit here, add janedoe@gmail.com. So that way then all of the different spots, that yeah, when you go to get stuff signed electronically, you want to make sure.
Oh, popular.
Um,
Nice.
phone numbers, have 2 spots for phone numbers as well. So, this agreement is between the broker and you as the sellers. I'm an agent of the brokerage, but the brokerage firm is the other side of it. And then, I am being designated as the agent, and you as the seller shall have an agency relationship with only Remax Platinum, me as the agent, and Joe DeCrew. So, it's an exclusive, that's why it's exclusive listing contract. No, they're not able to sign another listing agreement with somebody else while our contract is in effect. All right. And then, in consideration for this exclusive sale rights, we agree to use our reasonable efforts to sell the property, to present the property to other realtors through the MLS and engage in marketing. So then this describes the property itself. So yeah, the city of Howell.
Genoa Township.
Okay, well,
Osceola Township.
okay, so it's, all
Hey, listen.
Hard to get it.
right. The street address and all this, obviously, I did not type this stuff in. This came from public record. And I mean, as Bill was saying on Tuesday, it's totally fine the title company may come up with a more precise legal description, whatever gets autofilled, that's fine. Having the correct tax ID, that's important, along with the address. But yeah, that's when they autofill, so only on rare occasion should there be a problem, with the autofill. All right, so this section down here, though, covering the fixtures, this is important to know, because this is something that comes up. I mean, I had one that, we sold a house a summer ago, and the sellers removed the antique door knocker on the front door with, just when the buyers got the house, they were like, wait, where's the door knocker? And the seller's like, well, it was a family heirloom. It's like, yeah, but that's a fixture. And I had gone over all the concepts of fixtures as we were discussing the window treatments and everything that was, like actually affixed to the property. But I did not explicitly mention the door knocker, and they apparently didn't think to inquire, like, hey, does that count? So now what I thought was interesting in here when looking through it, is it was updated with the concept of the attached TV mounting brackets, because that's one that, over the last 10 years, there's definitely been a transition to that being much more common, and contracts not always being as up to date to make it explicitly clear, included or not, for things like that. So I'm happy to see that in this version, yes, TV, anything that's already mounted, the brackets themselves, you can take the TV with you, but leave the bracket behind.
And the wired smart home devices too, like,
Yes,
the Ring cameras are, if they're attached, yeah, that's a new one
So
too.
the Ring doorbell would stay.
Mhm.
yeah, oh yeah.
So we have to be very careful to go through this now and mark things out if the seller intends on taking that stuff.
Right, yes, yeah, because, yeah, I mean, anything like that, the Ring doorbell, I mean, that is wired into the house and is affixed to it.
Some of them are.
Well,
Some of
yes,
them are not. Some of you take off, charge, and you put back in the little
Yeah,
holder,
yeah,
whereas other are wired
But
into the
it's
house. I
still
had one of each.
attached, right? It's still attached.
No, the thing isn't attached, it's sitting in a holder.
well, so now if it's wireless though,
Yeah, mine's wired.
well, wireless does not be wired. So wireless smart home devices,
Okay.
I would argue, would not be part of this boilerplate here, because it's wireless. But anything that's hardwired in, at that point, yes, that's going to be, brought into this, unless, you want to exclude it, which you can type in those exclusions related to these things. You could say, the window treatments in the primary bedroom. You could say the lighting fixture, yeah, or that, family heirloom door knocker, whatever it may be, you can type it, write it in here. This spot is where you also include all of the personal property, ideally most commonly the appliances. That are going to be left with the property. So, a washer and dryer typically are not, a fixed, and so it's an extra personal property, but it makes sense to, include it with the sale. You get into trouble areas there if you have things like, pool tables or riding lawnmowers or things that are personal property that aren't appliances. That can then cause it's only becomes a problem with the buyer's financing, because if that's going to be part of the purchase agreement, it needs to make sure that no monetary value is being applied to it, because then it's going to disrupt their ability to get the appraised value for the home itself, the actual real estate, rather than
Should we
personal
put a
property.
clause in there, right there, if we're including the pool table, and say right there in the inclusions, that it has no monetary value?
That's not necessary for this contract, because this contract, I mean, it's just simply stating what our initial offer to the general public. But our initial
Oh,
offer to the
purchase
general
agreement.
public only matters if we get a cash offer with zero contingencies in exchange, which is basically somebody saying, we accept your offer to the general public. And so, yeah, I mean,
You address that on the purchase agreement.
that would be taken care of with purchase agreement. So now what's also lovely is this next section here. Oh, any questions from the Zoom audience about this? Since we have Zoom. And I'm just riding right through.
Actually, I don't have one about this, but back up on the first section,
Yes,
it has contract date, but I don't see anything for like a list date. Because sometimes you do your contract and then it enters in the multi-list, and in our old contract had two different dates. Here's our contract date and then our list date.
correct.
Just has one. So what do we do about that?
Well, and so, I mean, effectively, yeah, I mean, we're under contract, and when it's listed, I don't believe that actually is put into this contract, as to when it's going to hit the market.
So we just go by the rules, which says it has to be within 5 days or something, or whatever it is they say.
Well, I'm sorry, what was that about 5 days?
I think there's some kind of rule with MLS, like it has to be within 5 days or something.
Not really, not
Can't
for
remember.
this. If you, cause
Okay.
you can get a listing contract, and not instantly or within 5 days put it on the market, because like, we've had it before where we're assisting the sellers in getting the house ready to market.
Right,
And
right.
so, we're going to do our photography, and we're going to do all this stuff in preparation for the actual MLS. But we
Right.
want to be under contract with them early on, before we're spending money on hiring a professional photographer and all that.
Yeah,
Uh,
that's kind of what I'm asking, because the other one was, I think, 5 days for the coming soon. I'm missing, I'm messing those two up.
Yeah, so,
Because I've had things under contract a couple weeks, and then in our old contract, had the ability to distinguish those two.
well, yeah, so my understanding of this contract is it does not give us a firm date of obligation to have it on the MLS by. It gives us the authority to put it on the MLS. We're able to market it,
Okay.
through the MLS service. But it does not, because also if you think about it, my own personal opinion with the previous contracts is the coming soon concept kind of threw things into a gray area anyways, because the activation date versus the coming soon date, and so if it is going active on the 5th, but you're coming soon on the 2nd, you're signing the contract on the 30th. Yeah, what is the actual hit the MLS date? I mean, is it the day it goes coming soon, or is it the day it goes active?
Right.
So we are getting authority to list on the MLS, but we're not getting obligated to have it on the MLS by a certain date with this contract. Obviously, we want to do it when the sellers have, said they want it on the MLS by. But there's nothing in here that I'm aware of at this point that forces us to get it on the MLS by any certain date.
All right, thank you.
All right, so the year built, if you know the year built, you can put it in here. You can check one of these boxes. And yes, for those that are newer, in 1978 or later, we check this box. And what's nice is then, yeah, we don't have to, apparently, according to Bill on Tuesday, we no longer have to get the lead-based paint disclosure signed, which is a change in how I'm going to be doing business. I was still having my people sign even when the home was built after 1978. I was still having them sign that doc, but they were just checking the box and initialing saying that it was built after 1978, but still signing. So that form still existed in the additional docs uploaded into RealComp and all that. And my understanding, based on what Bill said Tuesday, is that we no longer have to do that if we're checking this box on the listing contract itself. Obviously, you want to make sure, and if there is any sort of uncertainty, was it built in 1977, 1979? If there's any uncertainty, have them fill out the lead-based paint. But if it's a home from 2003, check the box. Don't worry about that document apparently. I'm still curious if central office is going to change their processes to be okay if we turn in this file and don't have the lead-based paint. But yeah. So price terms. So again, as I mentioned before, this contract is our offer to the general public. And so if we put in a price here of 300,000, then what the seller is agreeing to by signing this contract is that if we help them find a buyer who's willing to give them 300,000 and meet all the terms of this contract, we have done our job and we become entitled to a commission. So this price here is something that they have to recognize, if that buyer comes along, they then, now the odds of getting a cash buyer with zero contingencies at this, at all the terms, very, very, very small.
And that's the only way that happens.
That's the only
Cash,
way
zero
that, yes,
contingencies,
yes,
that price.
yes,
Okay.
yeah, that's my understanding is,
Stop with contingency.
well, by that point, if they've gotten past all the contingencies, there's already a signed purchase agreement. I'm saying if we get an offer of this amount with zero contingencies, cash deal, all of that, like everything that we're telling the general public we want, we are obligated, they have an obligation to sell. And if they don't, there's certain repercussions. So that's something to be aware of. Now you can add additional subject to the following terms and conditions. And so that's where I don't actually know what you would put in this box, to be honest.
Well, if
Would that wouldn't be something that wouldn't have anything to do with the relationship between the buyer commission and all that. That wouldn't fit in there, right?
Well, so, 'cause, in other spots on this, we're going to talk about things like the possession. What else? Okay, so,
What about excluded people? Like if, I had a neighbor who's interested and maybe. put
Oh,
a
yeah.
Good person there?
that would not be here.
Oh, that's a different spot?
Yes, yeah, for, yeah, because this is, yeah, I remember on the one person or one party. There's a different form for that. And maybe we'll get to that. I don't actually remember now if that's on this document, but there may be something here. Oh, okay, so here's one. If it is that the sellers, it's going to be contingent on the sellers finding a house of their own to purchase by, September 30th. So if that was something that, yeah, they're agreeing to accept 300,000 for the sale of their house, but they want that contingency in place that, they need to find their next move by September 30th. And if they don't, they want to be able to back out, then that's where this would go. Is to add that clause there. So. All right, to the money. Listing brokers compensation. So, got the important new language in there. Brokerage's firm's fee for services rendered is not set by law and is fully negotiable. So that's in bold, and you can point that out to them like saying, hey, it is fully negotiable, but this is what I charge for my services. I have the ability to charge something else, but I don't have the willingness because I know my value. And I provide enough services and value that I charge 6% for this commission. And in addition to that, we have a $3.95 broker firm fee, but it's our broker compliance fee.
Jordan,
Yes.
I'm sorry, could I interrupt regarding number 5? So if somebody says, so you're not going to negotiate your fee because, this is what you've conveyed to them that I'm worth, this is what I'm worth. So that language of I will not negotiate, or if they lead us to say, I mean, well, you can't really lead me, but you know what I'm saying. Got to be careful with that language because you're actually not negotiating because you're explaining why this is what I'm worth, this is my value, and I will not, come down from that amount. Because that word negotiate is a big deal now.
No, okay. I actually, that's a decent counterpoint. Because
I guess there's a way we could cloak it differently and not actually use the word negotiate. This is what I charge, and so this is, basically, this is what my value is. This is what my fee is, without, I guess, saying the word negotiate.
I mean, I guess, saying that you're not willing to negotiate, may lead you to potentially some hot water. What I would then rephrase it as is, these are the level, these are the services I provide.
Mhm.
This is what I charge for those services. If you aren't willing to pay that much, then I have to scale back my services. But I mean, I want to get your house sold. I want to be able to actually be of value to you in providing quality marketing and maximum exposure and getting you the right sale, the best sale price I can for your house. And so if you're not willing to pay me the 6% for my full services, yeah, I'm open to negotiating, but understand that at 5%, I'm not going to do professional photos. You're not going to get what I'm offering. So if you want what it is that I'm offering, and that's what I'm comfortable doing for you, this 6% is what I am charging. And you're totally, able to go with somebody else if you would, feel that they can do a better job at a lower commission. So yeah, I guess, avoid saying it's not negotiable, like that you're not willing to negotiate.
Especially when it says it's fully negotiable in bold letters, right?
Yeah.
Yeah. Well, I mean, because what it used to be was that I leaned on the excuse of, hey, my broker requires me to charge 6%. I'm no longer allowed to say that because the broker cannot require us to charge.
Right.
We are autonomous individuals who can make our own decisions. And so we don't have to agree to something we don't want to agree to, but we're not able to make the statement that it's required of us to charge the 6%. It's us choosing to place that on our own selves as what we value for what we do. If you're going to pay me less than that, I'm gonna do nothing for you. That sort of thing.
Mhm.
So yeah, so that's what, like, it's fully negotiable at the brokerage level, but at the agent level, it's what you as an individual agent want to do with your business.
Right, and just choose your words carefully.
Yes, yeah. And so,
Thank
yeah, and that's where, yeah, if during the term, so the very, very first line here, between August 1st and March 31st, if anyone produces a buyer who is ready, willing, and able to purchase the property at this price and the terms, um, or for any other price, terms, or exchange to which the seller consents in writing. So if the seller at any point signs a purchase agreement, that is when the seller has agreed to pay the brokerage firm the $3.95 and a commission of 6%.
So are we sure that that can't mean a mortgage? Because it doesn't specifically say cash there.
For the ready, willing, and able.
Because
I
if
mean-
if they're pre-approved and they have, for a mortgage, that would be ready, willing, and able.
That mortgage would have to be fully underwritten, which I have on my house. The buyer already had a fully approved loan, like that individual was approved to get that amount of money,
Mhm.
but the loan itself was still contingent upon my house appraising.
Right.
So that's still a contingency in place that means they're not ready,
And
willing, and
every mortgage
able.
company will do
tomorrow,
that.
yeah.
Okay, all right, thank you.
But yeah, so once that buyer comes along, writing that cash deal, full price and all of that, at that point, arguably, in a court of law, we've done our part and the seller has agreed upfront to, owe us a commission and the $3.95. Further, if within 6 months, a 180-day protection period, after the expiration of this agreement, the seller sells, trades, or exchanges the property to anyone who became aware of this listing during our listing contract term, that compensation will be paid to us. Unless at the time of the sale, property is listed with another realtor company. So that's where that is a very significant clause of the unless at the time of the sale. So they're not able to cut out you as a listing agent entirely by waiting for the expiration and then just directly going straight to the buyer who is interested and working out a deal with them. But if they find some other realtor who will list it for $100, that other realtor could, in a way, potentially protect them and void the protection period. So that's unlikely, but I mean just plausible out. Well, I mean, because the more likely is it expires and then it lists with somebody else for a normal commission, and then it sells to somebody who saw it during the previous listing, but now because of the price drop, whatever, with the new agent, that buyer who liked it back when you had it listed, well, now with the new price and all that, they're giving it a second look and they buy it. Well, that current listing agent is getting the commission.
Mhm.
And the sellers, aren't on the hook to give you the commission, even though that buyer came along during your term. I mean, that would be a very difficult thing to enforce or just avoid altogether.
Okay.
Yeah, I don't really know a better way to craft that, because it can't be, if you're the listing agent who, okay, this house expired, so I'm going to try to get it as a new listing. But now anybody who comes along, the previous listing agent could say, hey, that buyer saw it when I had it listed, so I get to keep the commission and you don't, even though it's your current listing. That would be a really difficult,
Right.
practicality to
Okay.
deal with. All right, so for the purpose of the paragraph, sale shall include a subsequent sale pursuant to an option regarding also agreed vendor trade or exchange. receive. Yeah. Strange situations, but still, included in the boilerplate. In the event of litigation involving the compensation to be paid brokerage firm pursuant to this agreement, if broker is the prevailing party, seller shall reimburse the brokerage firm for its reasonable attorney's fees. So if we have to sue our client, and we win, then they gotta pay bills, expenses. Now, I mean, I've been in this many, many years. We have only once that I can think of sued one of my listing clients. And it's because they accepted an offer, buyers did the inspection, they, buyers were moving right along, and then the sellers just changed their mind. And they knew that by canceling, they're gonna be sued by everybody, because they can't do that without repercussions, but they were willing to go that route. So, I mean, these contracts can come into play, but it is very, very rare. All right, so this gets to be the fun part now. Shared compensation with broker procuring buyer.
So these three are in the same order as they used to be on the MLS. So sub-agent.
Oh, yeah,
Buyer's
yeah,
agent,
in
and then
real comp.
transaction coordinator.
Yeah.
Yes, right.
Yeah,
Okay, so they're.
but keep in mind, this is a statewide document,
Mhm.
and real comp is a regional MLS.
Right, no, I'm just
So,
saying for us, so
yeah.
for us to remember, they're just in the same order that they
Yes.
were.
I suspect,
that,
I
okay.
suspect that's just a coincidence, but yes, it's a useful way to
Perfect.
keep it in mind that,
Okay.
yeah, sub-agent, buyer's agent, transaction coordinator, not participating. So, let's go ahead and read it. Whether the listing broker will offer a portion of the listing broker's compensation, so a portion of this 6% set forth in paragraph above, to the brokerage firm producing the buyer is wholly within the seller's discretion and is not fixed, controlled, or recommended by law. Now, that does not mean we can't recommend it. We should not try to fix it or control it, but we should be able to put up a strong recommendation. That's a whole different class, though, if we need to get into that. Not recommended or controlled by law, the MLS or otherwise. Seller directs the brokerage firm to indicate by initialing. So if we want them to offer a portion of the commission to the brokerage firm producing the buyer while acting as a sub-agent, the said offer of compensation shall be blank percent of the price or X amount. My business practice, I'm not going to have them do this, because I don't want to deal with sub-agents. If they are willing to offer a portion of the 6% to the broker producing the buyer while acting as a buyer's agent, said offer compensation shall be 3%. So I gotta check the box here. They'll have to initial. I can put in here 3% of the sale price. This would be for transaction coordinator, which again, I don't want to deal with the transaction coordinator on the other side. So I'm gonna leave that blank. If they weren't willing to do A, B, or C, then it's not offer any portion of the listing broker's commission to the brokerage firm producing the buyer. So now keep in mind though, this is just the upfront, what they're agreeing to at the outset. Now, if they are adamant that they want upfront to say, no, they're not offering anything, that does not preclude them from being able to change their mind later on. And if offer comes in and that offer is saying, hey, sellers pay 3% to the buyer's agent, they could always agree to do so. They're just not agreeing to it right here. But keep in mind, if you're checking this box D, then that means this number up here is probably not going to be 6, it's probably going to be 3. And so you got to make sure then if there were any changes based on the purchase agreement, that it's all going to depend on how it's all written. So it's, at the individual instance level, you want to make sure you're not giving away your 3% to the buyer side, that you still protect yours. Um,
Hey, Jordan,
yes,
question for you on that part. What if we have an unrepresented buyer coming in, such as from a open house or off a sign call type thing? I know I'm still gonna wanna get, I guess what we call in the past, double dipping, you
yes.
know, where we get both sides. How does that get addressed there?
So now, arguably speaking, if a buyer comes along that is unrepresented, so
No.
there is no shared compensation because there is no broker procuring the buyer. So in theory, you don't have to share any of that 6%. Now, I know Bill has a different opinion as to what we should do in that situation. And it's on each of us to decide for our own business practices and client relationships. Do we, really want to still charge 6% and get to take that entire 6% when there is nothing being shared with another broker? That's because, okay, keep in mind also, we are offering compensation of 3% of the sale price to the other side. So even if they come along with a buyer's agent, yeah, we're offering them 3%, but that does not determine what they receive.
They're by a broker.
Yes, what determines what they receive is going to be spelled out in the purchase agreement, and it's going to be constrained based on whatever their buyer contract says. So if they have a buyer contract that says they're only getting 2.5, then their purchase agreement should say that they're only getting 2.5. And so then this listing contract saying that we were offering 3, that's not what we're actually going to end up giving them, because the purchase agreement says it's only 2.5 because it's based on the buyer contract. And so there's 6%. We're only actually giving away 2.5. So we get to keep the remainder. This, like, in theory, we're keeping the remainder of what's not shared. And so we could get 3.5 then, if the buyer's agent is only getting 2.5 because they signed a buyer contract at that.
So are we letting the other brokers title, whoever they're using as title, figure that out? Or are we going to be requiring not just an agency disclosure, but the whole frickin' buyer broker at this point?
So I have received I asked Michigan Realtors and their attorneys that directly during a Zoom call of, are buyer contracts still confidential documents, or can they be required by the listing side to prove the amount of compensation agreed to? And what they said, it is a confidential document, you do not have to share it.
Oh,
But that does not mean that the listing side could say, hey, okay, you don't have to give us the entire contract. You just have to have the buyers sign a document stating that they have a contract with you for 3% or whatever it may be. Like, the listing side can place a burden on the buying side, the buyer's agent, to prove that there is a 3% buyer commission. Whether, and most buyer's agents then would just send over the buyer contract.
mhm.
And also if
So
you,
they're allowed to share that. It's not confidential because as a hygienist, if I talk to a patient, there's confidentiality there. I can't share that. But that's not the same here, where if I'm the buyer and you're my agent, you can share that if I'm okay with it.
as far as I know, we are not precluded from sharing our contracts if we choose to do so. I don't think that the clients, I don't think we owe them a confidentiality of what's in our contract, especially when it comes to proving
So the
certain,
confidentiality is our confidentiality, not us between them.
right.
Okay, I got it.
Yeah.
Thank you.
So, but I thought the listing agent couldn't require that.
So they can't require the entire, but they can require some proof. that there is a contract in place between the buyer's agent and the buyer, that the buyer owes 3% to the buyer's agent, and that 3% can be satisfied by a commission. And so sending that contract over,
Just think it was up, but I didn't think that it was in our power to police that.
it now has to be in some regard. If you get because if you're the listing agent and you get an offer saying, hey, my buyer has a contract with me as the agent saying that they're going to give me 3%. So we're asking your client to pay that 3% to relieve my client of the obligation. It's totally fine for the listing side to be like, prove it. Prove that you have that 3% contractual obligation, and we'll agree to this. Like, it's a stipulation for agreeing to the terms. And
Jordan,
you're allowed to do that. Now, you could send over a heavily redacted buyer contract that just shows 3%, but eliminates all the other non-relevant content. But yeah, so I mean, that is how we go about handling this is still a little unknown. And so, I mean, when the situations arise, we're gonna have to just make sure we're aware of the potential pitfalls to avoid.
so Jordan, I have a question that's related to that, and I would think this is Kathy.
Yeah,
So as a listing agent, it's now unlawful to show a home unless you have a contract. So I thought as a listing agent that that confidentiality thing all went away and that we basically have the right to police that.
Oh,
Or
that's-
should,
that's
or
a good
should be
point.
policed under the guise of showing the home, nothing to do with the actual. So if somebody's gonna submit a listing, I would wanna say, it's offer, I would think I could say to them, well, it's unlawful to show the house, so can you please send your buyer broker over with it so that, because you were supposed to have that or something, not
Okay.
necessarily say that, but we don't, are those two tied together or am I missing something here?
so, right, and so that's where, yes, like, there's the concept of what it can remain confidential. What do you have to disclose? What can you avoid disclosing? So let's say you have a buyer contract where, yes, there's the commission of 3%, and it's, this start date, this end date, and all that stuff. But also in it is you have a $800 broker compliance fee that has no bearing whatsoever on the listing side. So that can remain confidential information. The listing side has no right to know what your broker compliance fee is. So yes, the listing side has the right to verify that you have a contract and are acting as a buyer's agent. But that's where an agency disclosure should be able to suffice for that, and not the entirety of the entirety of the contract should not be necessary to meet that threshold of acknowledging there is that agency relationship. Now, when it comes to you write an offer and that offer includes a buyer commission because you're claiming that the buyer is obligated to pay it, then at that point, yeah, the listing side can say, prove it. But, if you had let's say you weren't going to ask for a commission in the offer that you intend to write. You and the buyer have already agreed, okay, you sign this contract, at closing, you pay me $2,000, and that's it. And so, we're gonna write offers, and I'm not even gonna be asking for the sellers to pay my commission. You just know that that's gonna be a closing cost on your side. So, there's no reason anybody should need to see that the listing side should never have to see that buyer contract, because that has no bearing on what they need to be able to prove. If they need to prove that you're acting as a buyer's agent, you have an agency disclosure. If you're not asking for a commission, they don't need to prove that.
But do you have, isn't that enough unless you write an offer? Because the thing is, this is NAR's, it's now NAR requirement, right?
Yes.
Okay. Is it my job to enforce NAR?
By enforcement, oh, like if you're the listing
If I'm
agent,
the listing agent and I get it, and I
No.
get a showing, I don't,
You don't
I
have to.
no intention whatsoever.
Right.
Of calling the agent saying, send me your buyer agreement
Nope.
so I can
and
show it.
I am the same way. It's not on, like, no policing mechanism has been, or burden
Okay,
has been
that's what I
placed
was
on
trying to
us.
get at. That's,
Right, so it's totally, a listing agent could choose to ask for an agency disclosure before they even allow it. Just as the buyer's agent, there's no obligation for the buyer's agent to reach out to you, the listing agent, to say, hey, are you offering compensation, a shared compensation? That may become a best practice, but it's not required. And then, they don't do that. They show the house, they write an offer, and they write in the purchase agreement that there's 3% that they're asking the seller to pay. You as a listing agent can be like, well, hey, I'm sorry, but we were never offering 3% as part of the listing. And they can be like, that's fine, you weren't offering it. It's what we're asking for. It's
Right,
part of our
right,
offer.
right.
And so you either agree to it or don't. And if you don't, that's totally fine, and we can move on. But so yeah, so the policing as to what we are required to do in policing the other side, as far as I'm aware, we don't have any actual burden to do that. We have the ability to try to ask for proof. So when it comes to the buyer's commission, if we think that that's a no-name brokerage and they actually got a buyer's contract at much lower than 3%, and we don't actually want to share the 3% with them, so we ask them, hey, prove it, get your buyer to sign something saying they're obligated to pay you 3%. Then, yeah, I mean, we can do that. And if they can't back it up, or if we somehow, if they are stupid and send us their contract that shows they're only getting, obligated to get 1%, then we can say, hey, okay, you get 1% now because we're constrained by the buyer contract. And I'm going to keep 5% then as a listing agent. Or you could be like, hey, seller, because I, did my due diligence, I saved you 2%. You're only going to give 1% to the buyer side. Like that would be
because
the
you really
better.
you don't want a buyer, you don't want the buyer to pay them and us to pay them. The listing side to
Correct.
pay.
All right, is everybody okay with all that?
You like, hey, you're the one that asked for people to ask.
No, I
questions.
know,
You love it.
I know, but it's already been an hour and we're on number
That's what you
6.
get for asking questions.
All right, so, but yeah, so does not offer any portion of the listing broker's commission. This is for those that, I heard I don't have to pay the buyer's agent commission anymore. Yeah, you don't have to. It's smart to do so. It's dumb not to agree to do so. But okay, if you don't want to, we can drop this down to 3 and we'll do that there. All right, seller concessions. So since we're trying to figure out the terms by which they are, doing their initial offer to the general public, it could be that as part of that, they're offering 3%, seller concessions. The seller may be willing to consider, or not even an amount yet, but just the whole idea of, seller is open to considering offers that have seller concessions built in. I mean, in theory, yeah, it'd be silly for you to ever check not. Because if somebody's willing to give you, 310,000 for this house with 10,000 seller concessions, why would they want to upfront say that's not an offer they're willing to even consider? This invitation is contingent upon other terms being acceptable still. And this invitation shall or shall not be disclosed in the MLS. So I mean, in reality though, because Real Comp is going the route of other MLSs and going to have that pre-sale concessions field built into their forms, that's where this, can get into being part of the listing contract then. What's strange is it doesn't say an amount in this section. Whereas if you do the pre-sale concessions, you're actually, supposed to provide the amount. But all right, participating in the MLS. So the seller's authorizing us to put this on the MLS, and then that MLS is going to, disperse it out. Any questions on these seller concessions or MLS? I realize I should probably pause after each, just in case. So,
You want to be here 3 hours?
yes,
Keep doing
it,
it.
hey, it can be a 3 hour lapse. All right, seller represents the title to the property to be good and marketable title, and seller will execute and deliver a warranty deed, land contract, or other instruments of assignment or conveyance as shall be required. By agreement on a subsequent purchase agreement, seller will provide at seller's cost an owner's title insurance policy in the amount of the purchase price. So this is where you should be able to explain to them that, yeah, one of their closing costs is going to be an owner's title policy. And if they have knowledge that there is a problem with their title, they're in a way kind of committing fraud by signing this contract if they don't actually believe to have a good and marketable title. If they are aware that they're going to run into title problems, they should not be signing a contract to list their house for sale because they don't meet the whole thing with a ready, willing, and able buyer up here. They're not a ready, willing, and able seller if their title is not clear. And so anybody who knows their title is not clear should not be signing a listing contract. All right. Questions on title section? No. Default. All right. So if a sale is not consummated because of the seller's refusal to perform, then the total agreed upon compensation shall be due and payable upon such refusal. So that is where, this lays out the terms of the buyer ready, willing, and able to purchase the property, or if the sellers agree and consents in writing to any other offer, then this stuff becomes due. And so the default means if they choose to not go ahead with the sale, they refuse to perform, they are agreeing to pay all that stuff. Now this next part of this though, if the sale is not consummated because of the buyer's failure to perform and the deposit made is forfeited. So if the EMD, the buyers get cold feet and walk away 2 days before closing, they forfeit their EMD. The seller agrees that the EMD shall be applied first to reimburse the brokerage firm for all expenses incurred by the brokerage firm on seller's behalf, and that blank percent of the remainder of such deposit, but not in excess of the amount of the commission, shall be retained by the brokerage firm. So I'm going to be taking the opportunity to point out to my client, hey, I'm putting in zero here because I want you to be able to keep the entirety of the EMD if the buyers, change their mind and break the contract. I'm not asking for anything. That makes us, me as the listing agent look better. If I'm, if I had the option to put in here 50% or 100% or something else, and I'm instead telling them I'm taking nothing and they get to keep it all, that makes me look better. So I'm going to, even in my 3-minute speech of this, point that out to them because we should always point out the things that make us look better. Any questions on that? All right. Marketing. Brokerage firm may photograph the property and publish pictures, advertise the availability of the property through any medium, place a for sale sign on the property and remove other for sale signs, and show the property at reasonable hours. Seller acknowledges that the use of certain advertising will result in the contents of the property being made known to third parties and consents to such advertising. Seller acknowledges that brokerage firm has limited control over third-party marketing of the property. So this is to protect us because yes, by marketing real estate, there are certain liabilities that occur with regards to safety or, criminality. If people were to look at the photos and think, oh, wow, that's a really nice TV in the living room. And oh, wow, it's right next to that window that, if they don't keep that thing locked, I can open up the window, grab the TV and run away. We're not liable for that because, the sellers, by signing this contract, are giving us permission to take those photos and put them out into the ether. And yeah, when that happens, we don't control that information any longer. Lockbox access. Seller authorizes a lockbox to be placed on the property for showings. Right, and only, other real estate licensees to, give them access. So you should not be giving out lockboxes, again, based on our listing contract, let alone all of our other rules that prevent us. It's only to other real estate licensees should you give out lockbox access. Now, I know myself and others, we have violated that by giving it to inspectors and things. In theory, you need to get explicit permission from the seller, and even then, I think we may be violating rules if we give an inspector the lockbox combo. Well, yeah, but I mean, a lot of them hold licenses, I believe.
So if we have something written from the seller and by the seller, and signed by the seller, we could let an inspector.
Yeah, well,
Okay.
and again, I mean, keep in mind, the enforcement of when you violate a rule, what is the enforcement mechanism? Most of the time, you don't want to be in front of a judge.
Right.
That's the worst case scenario is,
That's the goal. Don't be in front of a judge.
if you are in front of a judge because the sellers are mad that you gave the lockbox to the inspector, then yeah, having that piece of paper, signed by the sellers,
Right.
giving you permission, but,
Not a problem until it is.
right.
Yeah,
And-
not wrong. Whoever has the best paper trail wins.
So, yeah, all right, brokerage firm is not responsible for the security of the property. So yeah, I mean, criminality occurs, during showings and all that. The sellers will not hold us liable, for the result of damage if, or theft. Seller agrees to refer to the brokerage firm all inquiries received concerning the property during the period of this agreement. So this is a fun one because of, when we're filling out our MLS sheets and we get to that spot that says exclusive right to sell or exclusive agency. And the difference between the two, exclusive right to sell, exclusive agency. The exclusive right to sell is what we should be checking. Because if we allowed the seller to take on inquiries and sell it themselves, without us, we would be exclusive agency, not exclusive right to sell. We are having them sign a contract that gives us the exclusive, they can no longer sell it themselves. And that's why inquiries is in this contract, because they are acknowledging that they will send any leads our way and not try to sell it directly without us, because we have the exclusive right to sell. All right, additional offers. Once a seller and buyer enter into a binding contract, the brokerage shall not present to seller any other offers unless the seller and broker otherwise agree in writing. So you have a pending listing and some random agent is like, hey, here's another offer for your house. I know it's pending, but here's an offer anyway. You are not obligated to show that offer to your seller. Just because somebody else came along with an offer, because, yeah, I mean, the sellers have already agreed to sell it to the one party, and you don't have to try to potentially disrupt things by saying, hey, we received this other cash offer for $1 million. Yeah. All right, professional advice. Seller acknowledges and understands that broker, its agent employees are not acting as appraisers. Is there a question?
There's just back.
Okay, back on this. All right, we are real estate agents. We're not builders, appraisers, accountants, engineers, environmentalists, inspectors, surveys, tax advisors, attorneys. So seller has been specifically advised to seek professional input or advice in these areas from those professionals as may be advisable and prudent. So that makes total sense. We stay in our lane, and there are other lanes in which other professionals exist. And so we would prefer to defer to them, and we recommend our clients to seek out those people. FERPTA At closing, seller shall provide an affidavit of non-foreign status and otherwise comply with the withholding provisions imposed by section 14, dot, dot, dot. So because at closing, it is a requirement for the title company is going to require the parties to sign FERPTA documents. It was nice to see that, because this was not in our contract, before, but it's nice to let them know up front, hey, you will be required at closing to sign these docs. Because if they were the type of people in which this was something they did not want to sign, it not being in the listing contract could be a problem, because at closing, they could be like, hey, I was never told I was gonna have to sign this document that I don't want to sign. So having it in here, that's where and this is a longer 6-page document, longer than what we've been using, but it does include things that maybe we should have been including this whole time. All right, possession to be given 0 days after close of the sale, subject to rights of present tense, if any. Agreement shall be binding on heirs, personal representatives, all the other legal stuff there. Non-discrimination, fair housing, do not discriminate. All right, letters of introduction, aka love letters. In the event a buyer submits an offer along with a love letter, the listing agent will or will not forward the love letter to the seller. You can decide up front, hey, if we get an offer with a letter from the buyers, do you want to read it? Yes or no? If they say yes, yeah, you can say then, okay, I will pass it along, but be aware that, if you use what the information in the letter as a basis for discrimination, you are opening yourself up to liability. So that's why you may want to consider at this point telling me not to send you such love letters, just to protect you from that potential outcome. It's up to you, seller, yes or no. But if I check this box, then you're less likely to take on that liability later on. Especially because, if we have this checked, love letter gets sent, we don't forward it on to the seller declines the offer, purchaser gets upset and claims discrimination, we can say, hey, there's no evidence whatsoever that we sent on the letter, and we even have our contract explicitly saying we would not send that letter out.
I really like this edition.
Yeah, so I mean, it's because love letters are a thing, it's nice to have this paragraph included. Yes, that is very much my preferred practice as well is, I want my sellers to get to know what the information is when it becomes appropriate.
Yeah.
It should not
I have,
influence,
I'm sorry, I have a comment regarding that. I'm not a big fan of love letters. That's just me.
yeah.
But what is our culpability if we, if we explain to our client, like you said, and they still, want the love letter and it is somewhat discriminatory and there's a lawsuit that ensues, do we get dragged into that?
After that last line says no, right?
Well, so, I, do we get dragged into that? Anybody can sue anybody for anything. Like, we would be named in such a lawsuit. Whether or not we can easily demonstrate like, hey, we should, quickly, should be dismissed, at least, as far as we're concerned. That's for a judge to decide, as sad as it is to say. But yeah, so obviously the safest route is to just not deal in love letters at all. And that's why, I mean, it's totally fine to say, hey, I am not comfortable, so I am checking this box saying I will not forward this to you. If you
I
want
agree.
an agent
I
who
agree.
will forward it to you, you need to find somebody else. You're allowed to be like, I am firm on checking this box, because that's just me and my level of comfort.
Mhm.
I don't want you to be able to force me to pass along something that could result in a discrimination claim.
Thanks.
All right, showing this was where on Tuesday we had a long discussion, and it turns out Bill and I were wildly wrong.
You're still able to admit it.
So you have a listing and somebody calls the sign and they want to see the property. We had the misconception that you had to become a buyer's agent to show that property. You do not. If you are already the listing agent on the property, you can show the property without a buyer contract. You are the only one who can show the property without a buyer contract. So that is why this whole section then exists, because if you show the property and that person wants to purchase the house, how does the seller want you to act? Do they want you to, even if you had a buyer contract with them, let's say it wasn't just a random sign call, but it was somebody that you'd already been showing, 10 houses to, and then you show them your own listing, is the seller saying, hey, terminate that buyer contract and, just for this property, terminate that buyer contract and act solely as the seller's agent? Does the seller want you to become a dual agent of both them and the buyer? Or do they want you to act as a transaction coordinator? Now, we don't do transaction coordination very often here. So really the question is, does the seller want you to act solely as their agent and the buyer is going to be unrepresented? Now, in that case, if you have a contract saying 6%, and you're going to share the commission with whoever's representing the buyer, but nobody's representing the buyer, you still get 6% in theory if you check this box. If you act as a dual agent, you still get 6% in theory if you check this box. So this should not influence automatically what your commission is. Instead, though, it influences what your responsibilities are. If you're a dual agent, you're not able to be as forthcoming about whatever you find out about the other party. You cannot, disclose that stuff to your other client. And so I have always told my clients, my sellers, that if I become a dual agent, I am not able to provide them with the same level of service as if I am solely acting on their behalf, just in terms of renegotiation after inspections or whatever may be the case. I know that I can't act solely in their best interest. I have an obligation to the other side. Therefore, if I'm decreasing my services, I'm going to be a dual agent at a discount of 1%. So I'll take 5% to be the dual agent rather than 6%. If I'm remaining just the seller's agent and this buyer is some random stranger that I don't know, or if it was somebody that was a client of mine, but they understand that if they are trying to purchase my listing, that I'm solely going to be acting as the seller's agent, and I'm no longer representing them, which would be a very awkward thing. But in theory, then I could take all 6%, or again, I could tell the sellers, hey, in that situation, I would still only charge 5% or whatever it may be. Now there's nothing in here to state that, but later on you do have the other here, and that's where we would typically write in the event a listing agent becomes a dual agent, parties agree that the total commission shall be 5%, whatever it may be. It's 3:20. This thing's going on. All right. In all cases of the above, the brokerage firm, so Joe DeKrug, shall be entitled to the total compensation above, so the 6%. The designated agent, which is me as the listing agent, will preserve any confidential information obtained during another agency relationship or in a prior or pending transaction or business relationship. So if I was the buyer's agent, but now I'm terminating that buyer's agency, that doesn't mean I can just tell my seller all the stuff I know about the buyers. Seller acknowledges and agrees that the preservation of this confidential information shall not constitute a breach of any fiduciary duty owed by the designated agent to the seller.
That's
So,
an
because in
important
theory, yeah, if I check this box, I should have to tell the sellers, hey, the buyers would be willing to pay this much, or they are offered this much on this other property, or whatever it may be. That would normally be the case. So this bold language helps to clarify, no, in that one regard of sharing confidential information, we are not actually acting as the seller's agent no matter what, because we can't. Like, I mean, you know, it would. Oh wait, I did kind of skip over this. All right, seller also understands and agrees that the designated agent can show the seller's property to and obtain offers from all prospective buyers, including buyers with whom brokerage firm has an agency relationship. Does that make sense, everybody? All right. If a potential buyer is represented by a designated agent within the brokerage, other than the capitalized designated agent, and that's where we got tripped up in this. The capitalized designated agent is you as the listing agent. The non-capitalized is other agents at Remax Platinum. In that case, Remax Platinum and Joe DeCrube shall automatically be deemed disclosed consensual dual agents. So Remax Platinum, Joe DeCrube become dual agents, but the designated agent, capitalized, aka the listing agent, and the non-capitalized designated agent, the buyer's agent, the other Remax Platinum agent, we are not dual agents. But if a particular buyer is represented by the capitalized designated agent, aka listing agent, the listing agent shall notify both seller and buyer and do that. So that's, yeah, this whole non-capitalized designated agent is what threw me off before, because that was,
Understand.
yeah. That's why contracts are fun. Just the fact of something being capitalized versus not makes a big difference. All right. Indemnification. Seller shall indemnify and hold harmless brokerage from any and all liability for any reason as a result of injury. Wait, did we already do that? No.
No, this is like if somebody falls on the property,
Yeah,
the other one
well,
was the criminality. Somebody breaks into their house, the security, this one's different.
right here,
Mhm.
release liability as a result of damage to the property
Mhm.
or personal property.
Right,
So damaging the property or theft, you're released.
but damaging people.
Getting hurt, you're held harmless. All right. Seller hereby acknowledges that broker firm is relying upon the representations oral or written made by the seller with respect to the property. So yeah, we're gonna trust them when they say certain things. So if they say that there was never water in the basement, we're relying on that. Seller warrants to us that any representations they have made are true, and that the listing agent is authorized to make such representations to prospective buyers. So if they say there's never been water in the basement, we can reasonably rely on that being a true statement from their perspective, and we can tell others that. If it turns out later on they were lying, and it can be proven that they were lying, we have this to protect ourselves at least. Unplatted lands. Seller agrees to grant the buyer a right to make X divisions. All should be what you put in there. Because why not? I've never understood why anything other than all, like, I don't know, why would the seller want to, I mean, unless the seller, really cares about what happens to those 40 acres in the future, and they only want to sell it to somebody, who cannot split it, so they're giving them 0 divisions. I don't know. Seller represents the division has been approved by the municipality, or it still need to be required if the
How do we know if it's a new division or not?
I mean, they should know if they're selling off well, I guess when you go into public record and you look at the property, is that property a portion of a property? Like, are you selling 5 acres of a 10-acre parcel,
Mhm.
or are you selling its own parcel? If it's already its own parcel, it's already divided. If you're
Right.
trying to, this is, I've only dealt with this when it comes to vacant land. Yeah, and it's a 20-acre parcel. And the sellers are only trying to sell five, the southeast quadrant 5.
So that's what they mean by new, is like more pending than new.
Correct.
Because like new, new can mean a lot of things. It's very relative.
Yeah,
So what they should say is pending.
well, I mean, it may be that part of the transaction, they haven't even started the process yet. I mean, I had that, I listed, it was a house with like 10 acres all along the road. And they were trying to sell the southernmost 3 acres, but they were kind of flexible. And they were waiting for the buyer to come along to be like, okay, we actually want 4 acres or 2 acres, like, they were waiting for the offer, and so it wasn't even a pending
Okay, so a
decision.
possibility or a pending is how to do that instead of new, really. Okay.
And so, yeah, the municipal approval of the division would have been required for whatever the sale ended up being, because it hadn't even, it hadn't even been, started yet, because it hadn't even been determined exactly what was going to be offered for sale.
Gotcha.
Seller agrees to provide the buyer a seller's disclosure statement. Agrees to indemnify and hold harmless the Remax Platinum and agents from any liability arising as a result of the seller's failure to comply with the seller's disclosure, including not limited to attorney's fees, all that. So if they lie on the seller's disclosure, they're holding us harmless. Home surveillance, seller understands that the use of an audio surveillance device during showings, open houses, or inspections of property may result in a violation of state and or federal criminal wiretapping statutes, but it shouldn't in Michigan, but it may. If it does, we don't want them to be able to sue us to be like, hey, you never warned me of that. So this is just us warning them. Limitation, seller and brokerage firm agree that any and all claims or lawsuits between the parties relating to this agreement must be filed no more than 6 months. So if they want to sue us, they got to do it within 6 months of this whole thing. Of the contract, the end of the contract. So they can't come back 4 years later and try to sue us over something. At that point, the statute of limitations says no. Electronic communications. All right, they're a thing. My words, I've spoken a lot in the last hour and a half, and kind of running low, but thankfully we're almost done. Parties agree that electronic signatures and initials shall be deemed to be valid and binding. That's the important part of this. This agreement constitutes the entire agreement between the parties. Any prior agreements, whether oral or written, have been merged and integrated into this agreement. So that's good to know. Like if they try to say, hey, earlier you said such and such. Well, if you end up in a court of law in front of a judge, this is saying, hey, whatever was said before this document was signed has no bearing anymore. This document is what matters. Because this agreement is the entire agreement. Undersigned, seller represents all parties in title, are a signatory on this agreement, may be signed in any number of counterparts. So in theory, if it's owned by the husband and wife, husband can't sign on their own. They know that the wife is supposed to sign as well. They need to, be signing with the wife. All right, so yeah, others where you can put in stuff, whatever it may be. And then cancellation can be canceled only by mutual consent in writing. Now, I often let people know, hey, it's not good business practice for me to hold people to a contract and force them to be, working with me if they don't want to anymore. And so as long as, unless the extreme thing happens, I don't hold people to my contracts. If somebody is not satisfied with my services and they want out of the contract, I'm very likely to let them out and give them that mutual consent in writing. But that is required in order for this to be canceled. Seller has read this agreement and acknowledges receipt of completed copy of this agreement. So if they're doing electronic signatures and that, they get electronic copies. If they're doing hand signing, wet signature, should have the ability to make a copy right then and there and give it to them. Any questions?
Probably way too long, it's gonna go longer, so.
Yes, so how many, I'm curious how many people are still, let's stop sharing, I want to just see on the Zoom, how many still made it this whole.
How many
It was a
what?
good class.
Oh,
good
we're up to
class.
11. It actually increased in the number of participants. You guys are real troopers. I appreciate it.
Is the next one, next week, is it at 2 o'clock as well?
I forget what I put on the calendar for the time.
I thought it was 11.
Oh, it is
or
11.
You said 2 at the, or vice versa or
No,
something.
because 2 o'clock next Thursday is the dunk tank in Ann Arbor.
Okay.
And
So
so
it's
I'm
11.
gonna have to go through the buyer contract a little bit more quickly to make it down to Ann Arbor in time to dunk Rob, because we should all be, getting our pitching arm ready and our money to go to charity so we can dunk Rob.
So it's at 11 o'clock.
Hold on, I see here in the chat, there were 2 little chat bubbles. Let's see. Don't give me that look.
You're the one that's complaining it's taking forever.
I just remember that if you mark it at home on Facebook, then you have to go by the coming soon rules. Yes. And then just a heads up, and they just said they are advising against. So Nakbar is advising against using the form we just went through. But well, our Nakbar is North Oakland County Association and Board of Realtors. But we are advising for the liability sake of, hey, let's place the liability on Michigan Realtors. If the forms are bad, it's on them. Rather than using our internal documents, you can still do that, but I'm going to be using Michigan Realtors, just because I prefer it. So thank you all for coming. I am going to stop the recording.
Well, thank you. We appreciate you.
Thanks again.
Yeah, thank you all.
Thanks very much.
Yeah.